A new I-9 employer sanction case has been published by the OCAHO court. ICE filed the suit against a small moving company in El Paso, Texas, which at the time of the ICE inspection only had 9 employees. ICE sought a penalty of $45,586 for 23 I-9 violations. On March 13, 2025, just 5 years, 3 days, and 1 pandemic later, the OCAHO judge issued her 42-page final order. Let's take a closer look at this case. It gives some great insight into the current state of the OCAHO court and how they're handling I-9 violations under the Trump administration. First, we'll do a quick review of the facts and learn a little bit more about the respondent, John Ferguson Moving and Storage LLC. Then we'll talk about whether it's a good idea to go pro se in OCAHO proceedings, which is what the respondent did here. That's when you try to represent yourself rather than using the help of an attorney. We'll see how that turned out. We'll also take a look at the respondent's unique good faith defenses. Hey, Judge, we only hire U.S. citizens, so we don't need I-9s, right? We'll see how that turned out. Finally, we'll take a look at the judge's 5-factor analysis and see how she calculated the final order. Was it higher or lower than ICE's proposed $45,000? Let's take a look. ICE issued the notice of inspection on March 11, 2020. The time frame for the inspection was 1 year, so from March 11, 2019 to March 10, 2020. The respondent was required to submit I-9 forms for all current employees and any employees that had been terminated during that prior year. 5 days later, ICE sent an agent to collect the required documents. The agent reported that when she arrived, the respondent's business dispatcher was in the process of completing 4 I-9 forms, including her own. The dispatcher told the ICE agent that she hadn't been able to locate any of their I-9 forms, so she was only able to submit the 4 that she was working on. And only section 1 of the 4 forms was completed, the employee attestation section. They were signed and dated March 16, 2020, which was that same day of the ICE visit, so basically confirming that the employees filled out these forms after ICE served the notice of inspection and months after each employee actually began working for the moving company. The second page of the forms were completely blank, including sections 2 and 3, where the employer is supposed to complete and sign under penalty of perjury. In the notice of intent to fine, ICE alleged 23 violations by respondent for failure to prepare and or present the forms I-9 and sought a penalty of $45,586. A somewhat unique characteristic of this case is that the company's owner decided to represent himself in the proceedings. Is this a bad idea? Well, let's take a look at what went wrong. Other than the obvious error, failing to do any I-9s whatsoever, we learned from the judge's decision that the owner made several more mistakes during the proceedings, which probably cost him more money than the attorney's fees would have. The first mistake, he made a lot of effort to do some corrective actions on the company's I-9 file, and he ended up sending a total of 17 completed I-9s to ICE. But he never actually submitted them to the court. The judge noted that the owner mentioned these corrected forms in the pre-hearing statement and in the preliminary exhibit list, but he never actually submitted any I-9 forms to the court. Now, although these forms were completed after ICE issued the notice of inspection, they still would have been positive evidence during the penalty mitigation phase. We'll discuss this more in a bit. Another mistake the owner made, he didn't file any exhibits at all. I mean, what's the point of going to OCAHO if you're not going to file any evidence to support your argument? The owner's defensive arguments were also not very effective. First, he argued that the company did not violate immigration law because it did not knowingly hire any unauthorized workers. But ICE did not charge respondent with knowingly hire any unauthorized workers. They were charged with failure to prepare and or present the forms I-9. So that defense wasn't really applicable. The respondent also argued that his moving company complied in good faith with immigration law. It's a small business with no human resources department, and all of its employees are U.S. citizens. And the owner verified the citizenship of its employees by reviewing their social security cards, so he claims. So that should be enough, right, under the good faith argument? Well, in her decision, the judge gave this the equivalent of an eye roll and found Respondent liable for all 23 counts. So, what was the judge's final penalty? Was it higher or lower than ICE's proposed fine of approximately $45,000? In her decision, the judge was quick to remind us that the range of possible penalties is based on the law in effect at the time of the judge's decision, rather than at the time of the ICE inspection 5 years ago. Is that fair? Well, it's in the statute, so there's not much we can do about it. In the complaint, ICE asked for the maximum possible fine because the respondent committed substantive violations in 100% of their I-9 forms. Back in 2020, the maximum fine was $1,982 per violation. But now, the maximum is $2,789 per violation, which is what the judge used to calculate the penalties here. So conceivably, the final penalty could be well above ICE's proposed amount. Well, as always, the judge turned to the 5 statutory factors. When determining the appropriate penalty to assess, due consideration must be given to these 5 factors. 1, the size of the employer's business. 2, the employer's good faith. 3, the seriousness of the violations. 4, whether or not the individual was an unauthorized alien. And 5, the employer's history of violations. For the first factor, the judge concluded that the moving company was a small business because it employs fewer than 100 employees. When ICE issued the notice of inspection, the company only had 9 employees. So, in keeping with OCAHO precedent and the general public policy of leniency toward small businesses, the judge concluded that mitigation is warranted for this factor. The primary focus of a good faith analysis is on the respondent's compliance before the investigation. In calculating the penalty, the judge noted that the court does not consider whether respondent registered with E-Verify as a sign of good faith, but focuses on whether or not the employer reasonably attempted to comply with its obligations under Section 1324A prior to the issuance of the notice of inspection. The judge also noted that although respondent asserted good faith as an affirmative defense and claimed that it verified its employees' citizenship, it had not offered any evidence of its good faith compliance. Evidence is key. So the judge concluded that neither mitigation nor aggravation of the penalty was warranted and treated good faith as a neutral factor. For the seriousness factor, this was interesting. In its complaint, ICE argued that the seriousness factor should be treated as neutral, but the judge ended up ruling that aggravation was warranted. Quote, a failure to complete any Forms I-9 whatsoever fundamentally undermines the effectiveness of the employer sanctions statute and should not be treated as anything less than serious, end quote. The judge also reminded us of OCAHO precedent regarding failure to complete any part of Section 2, including an employer's failure to sign his or her name. This is a, quote, serious violation. So, the judge ruled that an aggravation of the penalty for the seriousness of the violations was warranted. Now, had the owner submitted those corrected I-9s to the court, you gotta wonder, would the judge have ruled that mitigation was warranted here? I think maybe she would have. That could have reduced the fines quite a bit. As for whether there was the employment of any unauthorized individuals, ICE did not allege that respondent employed any unauthorized individuals, and its complaint stated that no aggravation of penalty is warranted for this factor. So the judge concluded that this factor should be considered neutral, under the rationale that compliance with the law is the expectation, not the exception. For the final factor, the judge found no evidence of prior violations of the law by respondent. And again, because compliance with the law is the expectation, not the exception, the judge concluded that their history was a neutral factor. So, what was the final decision issued by the judge? In the end, she decided that the violations did not warrant a penalty at the high end of the penalty range. Rather, the court exercised its de novo authority and concluded that the penalty should be slightly above mid-range. Final decision, $36,179.